talk about issues of federal and state regulation. And one of the things that we realized within this issue is that state regulations are not the same. It's very much like Medicaid, that for each state they have their own rules and their own regulations. And really, the issue of federal regulations that came out from the Department of Education highlighted how much discrepancy and disparity exists. So Dave is going to give us an overview of the legislation that really led to opening up this discussion.
I'm going to take it up to about 30,000 feet here, and then Mary Jo will bring us down to all the way down to Arundel College, where she's had to deal with this situation. But I'd like to take a little bit of a poll first. How many folks have had to deal with state authorization issues in your own state or your own institution? Hands high. So we have a few folks where that's the case. How many know what state authorization is? Okay. How many don't know what it is? Okay, so we've got a nice mix. How many folks have just realized you're in the wrong session and you'll be heading out the back door? Okay, nobody? Okay, we'll go ahead and get started. I want to just give a brief overview of the, I always want to say health. Whenever I see H in an acronym, I just want to see health. So if I make that mistake, please bear with me. But the Health, or Higher Education Opportunity Act, HEOA, or HEOA, is something that we're going to be talking about today. And we're going to define state authorization and state authorization reciprocity agreements as well that are referred to as Sara. And we're going to review one program's experience, which is Mary Jo's program. And we're going to talk about some potential next steps that you might want to take. Now, these are relatively passive learning objectives, obviously, and we don't mean them to be passive. We would like to have folks ask questions or interject or give your own personal experiences as we go through this process. Whoops. Right side up. Okay. So this was actually based on the Higher Education Act of 1965, and so the Opportunity Act was actually a reauthorization of the act that occurred in 2008 and started to produce some of the difficulties that we're all facing right now. So what is the HEOA? What is the Higher Education Opportunity Act? Well, we'll go through a little bit of history here. It actually was originally passed in 1965 as a part of Lyndon Johnson's Great Society efforts. And it's pretty remarkable to think about all the things that occurred during his presidency that have come down to us: the Civil Rights Act, Medicare, Medicaid, the Higher Education Act, and also first funding for community health centers was created in 1965 as well. So in that foment of the Great Society and attempting to solve a lot of problems, they also focused heavily on education as well. And the idea was to strengthen colleges by producing funding to support educational efforts, different than had been done in the past, where it was all basically very local or philanthropic in nature. And it was also the beginning of loans to our students. Have you heard of Pell Grants? Have you heard of Stafford loans and so forth? Well, all of those types of activities that provide support for education of undergraduate and graduate students can be traced back to 1965. They actually had a national teacher corps, not unlike the National Health Service Corps, to train teachers and get teachers into underserved areas. So there's some interesting overlap and overlay with the Health and Human Services and the Department of Education. Department of Education is usually referred to as ED, not for erectile dysfunction, but for ED. They just switched it around, Department of Education. The website is listed that way. There's been 9 authorizations since 1965, and it was amended and changed and updated each time. There's been some controversy at each step of the way. And in 2008, as I mentioned, the HEOA was enacted and reauthorized. And these include regulations requiring online and distance learning institutions to receive approval for the activities that they perform, and most specifically, where they happen to operate. Focus has been on internet-based and education programs. They obviously didn't exist in 1965. Everything was focused on brick and mortar, and whether or not you had a distance campus set up in another state, it would seem to be pretty easy to visualize that as something that would require involvement from a federal level. And of course, they want to protect the integrity of the financial aid programs. One of the major concerns is that there may be, with the ease of internet, the lack of control, lack of understanding of what's involved in curriculums, that unscrupulous educators or quasi-educators could produce online programs that would not really produce any value for the students while they were using funding supported by taxpayer guaranteed loans. But state regulators became newly aware after 2011 that this was really an issue that they had always been responsible for. And anyone training students outside the borders of the states was always responsible for, but it was just fairly insular in how folks approached it. They tended to look in their borders themselves and not really pay much attention to what was going on with outside institutions training students in their state. And the Western Interstate WHEd, Jeff, can you help me with this? WHEd.
This is
Western Interstate Commission for Higher Education. Russell Paulin said that as a result of some issues that came up in 2011, where some regulations were actually turned down based upon a technicality, and it was set aside, that all of a sudden states became more aware that this was actually a potential revenue stream for them to further investigate, evaluating, and essentially approving different educational institutions training students within their state borders. There's really nothing new, as I mentioned, about state authorization. The Education Department requires approval that educational institutions are accredited, and they have to have all their ducks in a row in order to have their students apply for student aid or loans. And generally, the federal aspect has looked the other way and left it up to the states to determine how they would set up barriers, fees, requirements for the different programs. States, up until this point, have done little about actually creating mechanisms for institutions to become accredited within their borders. HEOA was different in that it actually set a national standard, so a little bit more federal control at that point. Primary justification, of course, as I mentioned, is to protect students, to get away from diploma mills. There's often a push-pull between profit and non-for-profit educational institutions. And when this legislation came about, the for-profit institutions felt that it was unfairly aimed at them, that they were receiving increased scrutiny. And what it really means is you have to have documentation, and it could be all the way to outlining your whole curriculum that you have. And there are fees that range, as you can see, from a low of $100 to $10,000 per application in different states. And as I mentioned before, few of us have paid much attention to these requirements that may have already existed. And of course, states may view this as a significant revenue enhancer with relatively little overhead on their part. The Sara stands for State Authorization Reciprocity Agreement, and these are basically higher education compacts, and I think I've listed all of them across the United States. And they are interested in making it easier for institutions that reside within the geographic boundaries to have reciprocity across those boundaries. Of course, the problem may arise when you're going across the different regions and the different organizations. But they've actually developed ongoing and developing processes by which, if you're part of that overall educational organization geographically located, that you can actually receive reciprocity to have your students trained in any area, whether it's across state lines via internet or whether you're sending students for clinical rotations elsewhere. These are all voluntary. You don't have to do this even if you're in one of these regions. And the thing is, and I think it's important to keep in mind that these refer to institutions, not individual programs. And institutions receive reciprocity agreements, not individual PA programs. I don't know of any PA programs that aren't affiliated with an educational institution of some type or another. And so this applies to the entire institution. This is not $10,000 per student. This is not $10,000 per program. This is $10,000 per institution in most cases. And the fees, as you can see, to be part of a reciprocity agreement are between $2,000 and $6,000, or they're projected to be in that range.
Great. So how did this come on our radar from the GRC standpoint, or our Council of External Affairs? And basically, all of the institutions will receive letters, dear colleague letters, from the Department of Education. We have the Federal Register to come to. And so then the next slides have a few of the excerpts from the Federal Register where these were published. So in 2008, we had reauthorization of the law. In 2009, we had regulations that began to come out. And so the regulations are where the details are and how this is going to affect different institutions. And what the federal government requires is that the states do their part, the Fed does their part, and they have delegated regulations to the Department of Education, and the institutions do their part. And Dave has told us that really there was some laxity within how the states were really monitoring the higher education institutions within their borders, and maybe we're unaware of how many students were taking coursework from other institutions outside their borders. So really this regulation brought some attention to that level. And the reason is because we had an expansion of significant student aid. And at this time we were also seeing record levels of default. So there were issues regarding the regulation for integrity. And so many of these will be discussed moving forward. For us, as an institution, this came on our radar because the federal regulations required us to be named in statute. And as a community college, we had not been named in statute because we were established in 1961. So our leadership was very, very aware of the federal regulations and started working with a consortium of community colleges to revise this and work with our state institution, the Maryland Higher Education Commission, to make sure that we wouldn't lose our funding stream of financial aid. So this is a pretty wordy slide. I'm not going to read it to you, but this is the reference in 2010 that we started to pay attention to. This legal authorization to be able to provide higher education within a state and receive federal financial aid and funding. And so one of the other things that I've highlighted here is that we as higher education institutions are required not only to be in compliance with federal law, but obviously state laws of any states that we work within. Now hopefully that sounds somewhat familiar to you because that's also one of our accreditation standards. So what we did is we worked with our Maryland Higher Education Commission and we named all of the institutions that had previously been established since 1961, updated that within the Maryland Higher Education regs, which we call COMAR, and so that was resolved. At this time I was working on my self-study, and I knew that to be able to validate and verify that we were in compliance with this regulation, I would need that piece of paper. So not only would I need that for my site visit, but it also needed to be on our website for other stakeholders. So the regulations didn't stop there. The regulations pushed on saying that all higher education institutions had to be in compliance with state authorization across all states if they had a student within that state where they were not physically located. This raised a lot of concern, obviously with the growth of online programs, as Dave was saying, but also many of us were sending students to other states for clinical practicum, proctoring of exams. We had faculty in other states, and so we found that these regulations affected a much broader population than I think initially intended within the regulations. And so there was a U.S. court case that basically said, hey, look, they didn't go, U.S. Department of Education didn't go through the process of negotiated rulemaking exactly as it's supposed to be done. And so the rule about the state authorization was vacated. All right? And then the Department of Education appealed that decision. And they said, yes, the Department of Education does have the right to do this, to write these regulations, but they have to go through the process. So they upheld the vacated ruling. And so what we saw was the U.S. Department of Education pushed back on for multiple years enforcement of this. And the enforcement that they had proposed is that if an institution was not in compliance with state authorization, that they would not receive financial aid funding. So Title IX. So this was a pretty big deal. But through that process, the Department of Education made it very clear that despite that we have this vacated ruling, despite the fact that we're going to not enforce this with pulling financial aid, we expect you all to be in compliance with all the state laws of any of the states that you're practicing in. And so we hope that you know them, and we hope that you are following them. Well, for us, as PA educators, how many in this room feel that and consider that clinical training using volunteer preceptors from other states meet the definition of distance education or correspondence education? How many? One, two, nobody. One? Okay. How many of you consider clinical training using paid preceptors from other states to meet the definition of distance education or correspondence education? One of the things that was confusing, I think, for a lot of institutions was they felt that this was only requiring online education or only applied to online education. The reality is it depends on your state. There is incredible variability on what is considered a trigger of distance education that you would apply or you would have to apply for state authorization. There is as much variability within this than, as I would say, as there is in Medicaid. And so the good news is that there are states that you might not have to do anything to send your students to send them for clinical preceptings. And then there are states like my state in Maryland that has actually chosen to not participate in the Sara agreement, that you actually not only have to send an application to the Maryland Higher Education Commission, but you have to pay a fee. And that fee by institution is about $7,500, and that does include clinical practice. So here's the deal. Trigger activities vary. And these trigger activities can be pretty broad. They not only include advertising in local media, using direct advertising, requiring local proctors, employing faculty, or conducting internships and practica in the state. And what happens if we don't comply? This really got the GREAC, the council's attention when program directors in February got an email from the ARC-PA reminding them that they are to be in compliance with all federal and state laws or be found that you are not in compliance with the standard. So this was very much on our radar. You can get cease and desist programs, institutions can get cease and desist orders if you're not in compliance. There are fines that may happen. and then certainly financial aid consequences going forward. A lot of us had a sigh of relief when we found out from the Department of Education that they were not going to hold people accountable until 2013, and then they pushed it back to 2014. We felt that we had more time to get our ducks in a row, and that they were not going to pull our financial aid. Many institutions actually have waited this out and said, we don't think the regulations are going to be this broad. We don't think now that the ruling has been vacated that we're going to even have to do the state authorization issue. And so they've been rather stagnant. But one thing that I can tell you as we've, as a council, have watched this regulation is that in May, they are going through the negotiated rulemaking process. They have had a time of open comment. They have had, they're in the process of tabulating those comments and getting them ready for presentation. So we anticipate, as do many of the advising and watchdog areas, that these regulations are going to stay on the books. So if you want to know what the regulations are on a state-by-state basis, one of the best resources that we have found as a council and certainly as an institution is SHEO.org. All right, and this is the executives regarding higher education and authorization. And so SHEO.org, if you just actually cut and paste that link, you will get a list by state of who you need to contact to find out what requirements are in place by that state for you to become an authorized institution to send students or to have faculty from that state, or in some states just to advertise in that state. Now the good news is, as Dave told us, that there is a solution, and we have those 4 compacts coming together trying to streamline this process and leverage our accreditation standing of institutions to be able to not go through the labor-intensive work that I'm going to explain to you what our institution did to be in compliance. And the big takeaway of that is that that language was in draft form in August. It's still in process. It's not fully live yet, but it's coming. So keep an eye on Sara, the State Authorization Reciprocity Agreement. The other takeaway for this is that it is an option for states. All states do not have to participate with Sara. So the GREAC, we changed before I submitted, sorry. We have some recommendations as we move forward with this regulation, with following the Higher Education Opportunities Act, because we know it's going to be up for reauthorization in 2013, that at least each program has a clear chain of documentation that shows internally within the institution that this is a known concept, that it is, that the PA leadership as well as the institutional leadership are aware of this and they're in the process of compliance, that we should document and we should have proof of documentation of efforts to assure compliance with all federal and state regulations as we are required to do with the A standards, and save documentation that shows the program is receiving institutional support and guidance on this measure as you plan your clinical rotations. For all out-of-state rotations, our recommendation is to be able to show the steps are being taken to investigate and demonstrate compliance to state and federal officials and regional or program accreditors. I'm going to share our experience with you. I've alluded to it earlier, but as I said, this has been on our radar as an institution for a while, probably because of our institution type. The other thing is that we had an accreditation site visit in 2011, and we're currently planning for our middle states accreditation on the institution level. So there's going to be significant evaluation for that, and we want to make sure that we are completely ready for that. So we knew that this legislation and the regulations that came forward afterward presented a problem for us. So we knew that we had to be named in state statute, so we resolved that problem. And on a program level, so that's on an institution level, on a program level, in 2009, we began our preparation for writing our self-study for our 2011 visit. And we started digging in to how this legislation may affect us regarding clinical rotations with state authorization. And in particular, we were investigating our ability to verify and validate that we were in compliance with this standard. So while the leadership was working on making sure that our institution was named in COMAR regulation and by the Maryland Higher Education Commission, we followed dear colleague letters that we got on a yearly basis, reminding us and making aware of these regulations and the potential consequences of not being in compliance. And so what our Dean's Council did is they basically did an internal audit of all of our programs and said, where are your students, and where are your faculty, how many students are taking classes or enrolled in classes out of state, what types of instruction and length of instruction are they receiving. You may see Anne Arundel Community College and you say, oh, you probably just serve a 100-mile radius surrounding you. Actually, we have 56,000 students and we are present in all 50 states. So this was a significant revenue complication if we were not in compliance. So our institution basically spent a lot of time and effort to make sure we were in compliance and to look at this critically so we knew the cost-benefit, the cost-benefit ratio. So enrollment for the PA program showed that we have a 100-mile radius rule. So we have 8 required clerkships, and we don't send our students any farther than 100 miles from our institution. But that's still, because we're a small state, that still kind of trickles into 5 surrounding states. So that became our priority. We definitely knew that the majority of our clinical sites were within those 5 surrounding states, and that became our priority. And just as an example, when we were looking at Delaware, it took our institution 2 months just to get the appropriate data to prepare to do the study to submit for authorization to practice within their state. So, using the CO2011 Directory, our dean of the virtual campus sent a letter to the contact person for each of the states that we were operating in. And we requested to know what that individual state's process was for receiving authorization and what the fees were and associated with operating within their state. For our PA program, as I said, all 8 required clerkships are within a 100-mile radius. We keep them close anyway, but we knew that our priority was going to be those 5 states bordering us. And so for each state that we are currently operating in, we submitted approvals, and we can prove that we have approval to function in those states as an institution. Yeah?
And did you submit those approvals to
the states individually, or did you do that based upon the institution?
Right. So the institution basically sought approvals within the state to operate. So it was the institution, Anne Arundel Community College, that sent those applications, those fees, and gained approval to operate within that state on our behalf. So in 2012, discussions occurred regarding the impact of limiting clerkship elective rotations. We actually, typically 80% of our students come from Maryland, 20% come from out of state. Some of those states include Texas, Massachusetts, New York, and so we started looking at that and said, you know, we send 1 or 2 students very, very rarely. How many other students are the institution educating in those states? We need to look at this critically. And so we got guidance from our dean that we could not send students outside of our five state radius. And so I actually had one appeal of a student who wanted to go to New York, and we said, you know, we're curtailed to this. I can't authorize that. I don't have state authorization at this time. And actually, New York has not only a state body that I had to go through, but also a professional body that I would have had to gone through. So that appeal was elevated to the level of the dean after her review of the student and the issues and the fees and the state authorization paperwork that we needed to go through that was not yet completed. Her request was denied. So currently, when I presented this for evaluation, it was August 28th, and we had authorization, and there were 9 states that we were still pending authorization in, that we were not allowed to operate in until we received authorization. And we've decided as an institution that we may not operate in some of those states, and we may not recruit faculty from some of those states. So for accreditation purposes at this juncture, should ARC-PA come calling, I can tell them that I'm able to point to a process, a responsible individual within the institution who has this on their radar, and documentation showing that trail of communication and continued compliance, because we see ARC-PA moving from an event accreditation to a process, so continued compliance with all federal and state law. So HEA, so the Higher Education Act, the Higher Education Opportunity Act, is a moving target. We have seen these regulations come out in 2009. We've seen courts vacate rulings. We've seen appeals. And now there is most likely going to be another regulation issued in the future. HEA is actually up for reauthorization in 2013, but as you know, we have a political process that is pretty much at a stalemate, so we don't know how long that's going to take for reauthorization. And then typically it takes about a year for regs to be written. And I will say that this administration likes to write regulations. And they like to write pretty lengthy regulations, so it sometimes takes longer. So we're going to monitor this from an external affairs standpoint and a government relations standpoint, because we felt that it was important for the membership to be aware of obviously the state authorization issues and how it might impact clinical training, and it may affect some of the initiatives that are ongoing at the association issue. We're really unsure about what the future will bring. This is a lot of work. When I go into my associate vice president's office, who is tasked with this assignment, she has a binder for each state. It's about a 4-inch binder, and it has all of that communication, all of the requirements, everything that we've done up to this date. And the states that are flagged are the ones that we are not allowed to participate in as an institution. It does not only affect a program. And there is significant talk about how these regulations are going to be revised, rewritten, but they do feel that the state authorization is going to continue to be something that the Department of Education will be discussing and stressing compliance on because of the issues regarding student debt. Because, as I said, it really takes engagement of not only the federal government, but the state authorities, as well as the accreditation and institutions to effectively manage financial aid. And everybody has to be playing their part. And it seems that there are some within that equation that have dropped the ball a little bit. And it most likely is because of the rapid expanse of online education. And I think that many of us really kind of ignored this law, thinking, oh, it only really affects online programs. But as we are doing clinicals in multiple states and sending our students to multiple states, there are states that those trigger activities include sending a student for a clinical correction. So state authorization is the law of the land, and by accreditation standards, we must be in compliance with all federal and state law. So we wanted to raise awareness about this and discuss it with a greater forum, and I hope that you found this somewhat helpful. We were really afraid that we wouldn't have time for questions, but I think that we do. And
I would like to just give a little perhaps contrast to Mary Jo's experience. I'm at the University of Utah, and I about 6 weeks ago called our council that is specific to our program, to our department, Scott, and called Scott up, and I got an interesting email back, or I sent him an email, and he said, I'm out of town for 3 weeks and will not respond to email, and call this number if you have an emergency. I didn't know that lawyers could actually be away from email. It's pretty remarkable. So anyway, about 3 weeks later, he came back and he said, you know, I've heard of this. I've heard something about this, and I can't remember where I heard this. I think somebody's working on it. And I got an email about 20 minutes later back. Oh, I know who, she's right across the hallway. It's Kelly, and she's working on that. I'll have her get back to you. Well, 2 or 3 weeks more go by, and then I send her another email on Monday of this week saying, do we have anything I can share at the conference about how the University of Utah is responding to this? And she says, well, I was hoping to have it by the end of the week. Well, this is the end of the week. And if not, then Monday or Tuesday. So it gives you an idea of one institution's difficulty with this has caused all kinds of heartache. Not necessarily a great deal of money necessarily, just time has been a problem. And you can imagine if you find out that you get a cease and desist order from a state where you've got 6 students right in the middle of rotations, it could be rather troublesome. But that's one end of the spectrum for how on top of things her institution has been. Mine, lost in the shuffle, at least as far as I know at this point.
And Dave's experience is not unique. The WICH basically have been doing surveys on state authorization and how informed administration is on this topic. And there are a lot of people that had no idea about what the responsibilities are and how it would impact their institutions. And so WICH has actually been trying to do a really good job of informing folks of where resources are available, doing webinars on this. They've been involved in the Sara process and negotiations and that draft document that was released in August. So there are solutions out there, but in the interim, or solutions coming, but in the interim, I do recommend that you consider looking critically at where you're sending students and having a dialogue with your institutional officials, because I'm sure it's on their radar. Anything that affects financial aid with students is going to be on their radar. What we found from the Dean's Council's required audit is that the institution really wasn't aware of how many students were in each one of the states. And when we gave them that information, it allowed them to look more critically at the risk-benefit ratio as we moved forward and prioritize our state authorization process and work. So, yes?
Is PAEA kind of pushing for specific advocacy at the federal level related to this, or is it still just kind of waiting to see what?
Peter, would you take the microphone? I think they want to capture that.
Sorry. The question was, is PAEA pushing for a specific advocacy perspective on this at the federal level?
I think with all advocacy, we talk about this oftentimes on the council, is that we need the data. And so we really need to be informed of how this is going to impact our member programs. And at this juncture, I don't think that we really know that information. I mean, there are some programs like our program that stay within a 100-mile radius, and I can quantify and qualify the impact to our program. I can tell you work hours that was associated with this. But we don't have that data on a larger association level, so really having that would be valuable as we consider an advocacy agenda.
It would, but I think we can make the assumption that it is going to be widespread and touch probably over 90% of programs, I would imagine. In fact, maybe closer to 100% of programs in a given academic year or clinical year. And what we've decided to do is to present this here and make sure that we have a way of commenting, of giving our input to ED, to the Education Department, to let them know that we're concerned about this. The issue that becomes problematic is institutions are so different across so many different lines. And there will be some institutions that have gone a far piece down the road getting this all taken care of, and their ducks in a row. And I guess fundamentally, do states who have students, who have residents, who are living within their borders, who happen to be, or even if they're not residents, but they're receiving training in their state borders, don't they have something to say about the quality of education? You know, I think we can say that, yes, they do. And as we pointed out, this really existed before HEOA.
Right.
We just all ignored it.
Or we just didn't know about it.
And the states, it wasn't on the state's radar either. So I think regardless, we know that we got to pay the piper at some point.
I would suggest we separate the online from the clinical and, you know, maybe even push. We were talking yesterday at the town hall meeting about the difficulties in establishing primary care sites or sites in medically underserved communities. There are some programs where there are really a fairly small number or geographic locations for medically underserved communities, and it would seem that that would be another impediment to sending students to another state where there's a great need.
Yeah. I think we can't expect them to say, okay, hands off. Send your students anywhere you want to. That's not going to happen. And so there's going to be some price to pay. Yeah.
There was a recent comment by SHEO, actually, that basically said to states, hey, look, if we can get this reciprocity agreement going, and if we can make it something that is reasonable, that we're looking at accreditation agencies that we know are reliable, that they've got a handle on this, then please, you know, they've been pretty much begging with the states, then please work with these institutions so we do not create barriers to educating our populace, right? Fortunately, from an advocacy standpoint, we actually have a lot of partners that are equally concerned about this. Nursing is concerned about this. Physician training is concerned about that, even though most physician training tends to stay pretty close to the tower, right? But I think that we can work with our colleagues to seek clarity, to provide, you know, better understanding of how these may impact us, and work to raise awareness.
And I know none of you have ever had the experience where people have forgotten about the PA program. You've never had come up against that. If you're in a large institution with multiple health professionals being trained, it's very possible, especially if you're in a big ivory tower kind of a situation, where they could completely forget about having you at the table.
Right.
We have a little experience with that. Did you have a question?
Yeah. Are the fees associated with the reciprocity agreements and the state authorizations, are those annual or one time?
I don't know.
Off the top of my head, I don't know. I think that they are actually recurring fees. There's also another network. There's an SAN network to keep institutions informed about the ongoing efforts for Sara, and I know that there's a fee with that as well.
Also, kind of a comment also, we have a program where I'd say 30% are from outside of our state, and I could see this having a huge impact on our applicant pool and who actually can come, because they often come saying, may I do an elective back home? So this is really very important to consider long term, and who our students are coming and which states we're drawing from as well. I do have a question. I live in New York and I live in New Jersey. I work in New York and live in New Jersey, and I'm interested also recruitment. I can't go to my local high school unless I know and say I'm from Cornell and you could come to. Is that I saw that as a trigger, so I have to investigate that as well. Correct?
So if you are authorized as a state to operate within that state, you are in compliance. But I'm sure that you're in compliance as an institution within your state. If you go over to Massachusetts and you want to advertise about your program, you need to know what the triggers are within that state. And I'll tell you, Massachusetts is one you want to look at.
Hadn't even thought of that.
Yeah.
Mm-hmm.
I just want to thank you, Dave, for bringing up the large institution, because I found out about this. I sent it to our medical director, and I'm under the School of Medicine. They had seen it, but they didn't think about it for us. And so I'm still pushing it with our medical director to continue to go higher and higher to try to figure out what is going on, because I didn't know anything about it. They had seen it, but I guess, like you mentioned, the medical students are on campus. They aren't going out across states. And so bringing them back into that mindset of, yeah, there's a PA program and we do go out of state, I think is really important. So whatever we can do to provide more info, I've copied everything and have been sending it up and keep sending it up and keep asking what's the status. So.
And just doing that and following that paper trail and saying that you have worked with your institution, within leadership within your institution, to work toward compliance, et cetera, I think that that's very important. So keeping that documentation, do you agree?
Absolutely.
And I get that actually maybe tails into my question is, so, you know, at your institution, you're actually implementing this and people aren't able to go to certain places. Right. Whereas at mine, this is just in discussion. So in the meantime, as all of this discussion is happening, does PAEA have any recommendation for students who are currently out of state? I mean, I have several students who are currently out of state. Right. And having just learned about this and knowing that my institution is in discussion, do you have any advice for, I mean, if it's just a paper trail saying we're working on this, right, versus, you know, are we violating something, right, significantly at this very moment with my student in Michigan? Right. You know,
I think the best that you can do, because this is really unroofed a big issue for us. I think the best that you can do is you're not going to pull everybody back. You're going to say your steps that you're working toward to be in compliance. And document that you're moving toward compliance. Certainly when regulations go into effect, we have a timeline for compliance. And the Department of Education have given us, you know, they backed up the timelines, and now we're backed up to 2014. But it should be on the radar, and it should be discussed, I think, at the institution level.
Bringing up an issue like this is problematic and has some risk, because it can be like Chicken Little, you know, running around, sky is falling kind of a thing, when in fact the sky isn't falling. If you talk to somebody in your institution and they get excited about it and they're going to have to pull your students back until we get this figured, it's really not of that caliber. And that's where we're trying to give you the heads up on this now, so you can be working, creating the paper trail, and making sure your institution is doing what it needs to do, either regionally or nationally, to become authorized.
I'd like to thank our speakers. If there are further questions, I'm sure that they'd be happy to entertain them in the back of the room. Thank you so much.
Thank you for coming.